Today we will debate about consent that personal injury does not constitute tort. And representative of component side. First of all, what is tort? The Civil and Commercial Code section 420 said, a person who willfully and negligently unlawfully injure the life, body, health, liberty, property, and any right of another person is said to commit a wrongful act and is bound to make compensation therefore. Therefore, the assault of others is considered as a delict of the law in section 420, which can clearly show that first, acting against others illegally. Second, deliberately or negligently, and thus damages to other people. So my topic is consent that personal injury does not constitute tort. I strongly believe that consent personal injury is constitute tort because the assaulting people with consent or not regarded as causing others to get hurt and causing damage to others is considered illegal or violating good, moral, or contrary to public order, and whether it was done intentionally or negligently. When the result of damage has occurred, then it can be considered that causing that other person to be damaged, regardless of whether the offender will receive the consent of the victim. If it is the use of one's own physical strength to do to the other party is a physical attack. Therefore, it's not always be mindful. If the victim is aware of a person and always control himself not to do more than what the victim is accepting to do, it's not always be aware the use of physical force to hurt the other party. Even if the subject was consent, which is if done constantly, it will be more liable. Therefore, must be aware and self-aware in the action and always accept the consequence later by oneself, because the law foresee and aim to protect the victim.
I am the representative of supporting sides. I cannot agree with your point. G plus cover a wide category of directly inflicted civil wrong. G plus to the person include direct physical assault and treat to do so. The action must be volunteer in the sense that it must be under conscious control. There are many cases that are not taught. First is the medical case. Medical practitioners' liability claim may be taken against medical practitioners on the basics of the battery. This may sound intuitively surprising. A battery is a tort involving the direct application of force to do body consent is a defense. The second is the defense to personality plus self-defense may be a defense or through assault and battery. The force used must be reasonable and proportionate. In the circumstance, the right defense third party may depend on the circumstance and the relationship with the person defense. The principle of the consented personal injury. That is the injured person allowed to do something with them thought is an illegal action. So when people allow other people to violate, that is not thought because they consent the actions. Professor Sorasit J said the injured person allowed to do or get willingly in the dangerous situation. That is not the thought. There are the three of consented personal injury. Firstly, the injured person must to allow the action. Secondly, they have to allow before or during the action. Lastly, the injured person must allow willingly. To sum up, I am strongly agree about the principle of consented personal injury.
In case of principle of law, says the regulation that consent personal injury does not constitute tort. It is correct with the social moral and traditions. I think sometimes it's okay. In my opinion, I am agree whether consented personal injury does not constitute tort or delict is a term in civil law jurisdictions for civil law. Consists of the intentional or negligence must of duty of care that inflict loss or harm, and with the trigger legal liability for the wrongdoing. In my opinion, the injured person agree to act. The actions equal to accepting the damage to himself, causing that act to be a violation. That consent must be given before actions, or by giving consent before actions can be given as long as possible. So, it is still considered consent, and that consent must give directly to one's, especially in the case that the patients consent to the surgeons. The surgeons must use the equipment in order to do something with the patient's body. If the surgeons does not get the permission from the patient, the act of him is constitutes tort. Finally, it's easy to describe whether consented personal injury does not constitute tort.
My name is Korn K. I agree that consenting to violation is still to commit a wrongful act. The law does not focus on the person who consents to commit a wrongful act, but the law does obviously focus on the person who commit a wrongful act. It's easy to say it's about who break the law, because according to the section 420, a person who willfully or negligently unlawfully injures the life, body, health, liberty, property, or any right of another person is said to commit a wrongful act and is bound to make compensation therefore. That means the law has laid down clearly the principle that willfully or negligently. For instance, suppose that there are a man and a girl and a woman. A man arouses a woman to kill him with the gun, and a woman accepts it. A woman would have been offender since she has aimed the gun to the man, in charge with attempted murder. In addition, it has to consider in case by case. In some legal acts, it has an exception, such as a fictitious declaration of intention, a fraud, and duress. Anyway, I still strongly agree that consenting to violation is still to commit a lawful act. Thank you.